Welcome to this deep dive. We're here to unpack complex information and give you a clearer picture of key topics.
And today, we're looking at something pretty fundamental, contract enforceability.
Right. The idea that when you make a lawful agreement, it's binding. It's almost like creating your own private law, you know?
Yeah.
That's Article 1731, paragraph 1 in the framework we're looking at.
But what happens when those agreements, well, aren't kept? When someone doesn't follow through? That's where the legal system steps in.
And that's our focus for this deep dive, exploring the remedies when a contract isn't performed.
Exactly. We're aiming to navigate that landscape, looking specifically at what options are available based on the materials we've reviewed.
Okay. So we've gathered the key points from the legal framework on this, and it seems to boil down to two main paths when there's a breach, doesn't it?
Pretty much. You can either try to force the other party to do what they promised, that's enforcement or cancellation, or you can seek money for the harm caused, compensation for damages.
Article 1771 lays those out. Enforcement, cancellation, compensation.
Yes. So in this deep dive, we'll clarify these remedies, how they work, the steps involved, the conditions you need to meet when things don't go according to plan with a contract.
Great. Let's dive in then. So before you can jump to enforcing or canceling, there's usually a first step you need to take, right?
Generally, yes. You typically need to formally notify the other party, put them in default.
That's the mise en demeure, the default notice. Article 1772 mentions this as the general rule.
Correct. It's a standard procedure. You need to issue this notice formally demanding that they fulfill their obligation.
So it's like a formal legal warning shot saying, hey, you need to do this.
Precisely. And interestingly, the notice itself doesn't always have to list the specific penalties that might follow. Its main job is just to clearly demand performance.
Okay, clear demand. But like most legal rules, there are exceptions where you don't need this notice. Article 1775 covers these.
That's right. Several exceptions. The first is for obligations not to do something.
Like a non-compete clause. If someone agrees not to open a competing shop, and then they do.
Exactly. What's the point of sending a notice telling them to stop doing what they contractually promised not to do in the first place? The breach is already complete. It's self-evident.
Makes sense. The action itself is the proof. What's another exception?
Obligations that could only be performed within a very specific time frame, and that time has passed. The article uses phrases like compelling expressions or necessary implication.
Right, like ordering flowers specifically for a wedding day if they arrive the day after.
Precisely. The performance window was absolute. Delivering late is effectively non-performance in that context. The very nature of the agreement implies that strict timing was essential. No notice needed then.
Got it. The deadline was everything. Okay, what else?
Well, a pretty straightforward one.
Right.
The debtor tells you in writing that they won't perform.
Okay. If they've already put it in writing, no need to formally demand it again.
Right. And the last main exception is if the contract itself actually says you don't need a default notice in certain breach situations.
So the parties can agree beforehand to skip that step.
Yes, within limits. It shows the importance of party autonomy, letting parties shape their agreement, as long as it's within the bounds of the law.
Now, Article 1774 mentions that the creditor, the person owed the performance, can set a reasonable time limit in that default notice. What's the point of adding a deadline there?
It can be quite useful. First, it avoids ambiguity. It clearly states you have X amount of time to fix this.
Okay.
And second, if the debtor still fails to perform within that reasonable time frame you've set, well, it can strengthen your position later if you decide to, say, cancel the contract without going straight to court.
But the key is reasonable, right? You can't just demand performance in an hour if it's a complex task.
Absolutely. An unreasonably short deadline won't hold up legally. It has to be fair, given the circumstances.
Okay, so let's say we've sent the notice or an exception applies. Now we want the contract fulfilled. Let's talk about enforcement or forced performance. Article 1777 seems to say you usually need court authorization to make someone perform an obligation to do something, especially at their expense. Why involve the court?
It's largely about protecting the debtor, ensuring fairness, and preventing overreach by the creditor. The court acts as a neutral check.
Due process.
Essentially, yes. To make sure the enforcement is legitimate, proportionate, and doesn't unfairly burden the person who has to perform. It stops creditors from taking matters into their own hands in potentially problematic ways.
Right. What about those not-to-do obligations again? If someone did build that competing shop despite the contract, Article 1777, paragraph 2, talks about destruction or injunctions.
Yes, if the breach involves doing something prohibited, the court can authorize remedies to undo it. So in your example, the court could potentially order the competing shop to be closed down, maybe even dismantled.
Wow, really?
Yes, and at the expense of the party who breached the contract. The court could also issue an injunction, a formal order telling them to stop the prohibited activity and not restart it.
Okay, so real teeth there. Now, what about obligations to give something? It seems to depend on what needs to be given.
It does. There's a distinction between fungible things, items that are interchangeable, like grain or oil, and specific unique items.
Right, so for fungible things, Article 1778 talks about purchase and replacement. How does that work?
Okay, imagine you contracted to buy 100 tons of standard grade wheat, and the seller fails to deliver. The court can authorize you, the buyer, to go buy that same amount and quality of wheat from someone else.
And the original seller pays.
They pay the difference, yes. If the replacement wheat costs you more, the defaulting seller is liable for that extra cost, plus any reasonable expenses you incurred finding the replacement. It lets you get what you needed.
It makes the buyer whole, practically speaking. What if the obligation was to give something specific, like a particular painting or a designated piece of land?
For unique items, enforcement usually proceeds through the rules of civil procedure. The court can issue a direct order compelling the debtor to hand over that specific thing.
And if they still refuse?
Then the legal system has ways to enforce it, like having court officials physically seize the item and transfer it to the rightful party under the contract.
Okay. Now, there's a limit here, though, related to personal liberty. The law doesn't like forcing people to personally do things against their will.
That's a crucial principle. You generally can't get a court order forcing, say, a specific musician to perform a concert or an artist to paint a portrait if they refuse. That veers too close to compelled personal service.
But there are exceptions. The text mentions forcing someone to vacate a property.
Right. That's seen differently. While you can't compel personal labor in the same way, enforcing property rights, like eviction from a property someone no longer has the right to occupy under a contract or lease, is generally permissible. It's a balance between enforcing agreements and protecting fundamental freedoms.
It's worth noting here, the legal framework we're dissecting, particularly on the formation and effects of contracts in Ethiopia, owes a great deal to the work of George Krzeczunowich.
Ah, yes, absolutely. His book, Formation and Effects of Contracts in Ethiopian, is a cornerstone text in this field.
His analysis really provides much of the foundation for understanding these principles we're discussing. You can see his influence in the structure in detail here.
Definitely. His scholarship is invaluable for anyone trying to get to grips with Ethiopian contract law.
Okay, so we've covered forcing performance. But what if the problem's on the other side? What if the creditor, the person supposed to receive something, refuses delivery without a good reason? Or if delivery is impossible because of the creditor?
The law has answers for that, too, to protect the debtor who's trying to perform. Articles 1779 and 1780 cover this. If the creditor wrongly refuses delivery,
Like, they just won't accept the goods.
right, then the debtor can deposit the item maybe in a warehouse or somewhere the court approves at the creditor's risk and expense.
So the debtor washes their hands of it, in a way?
Essentially, yes, they've done their part. And Article 1780 says the same applies if the creditor is unknown or can't be found, or if something about the creditor makes delivery impossible. And importantly, no default notice is needed from the debtor in these cases.
Okay, so the debtor isn't stuck holding the bag indefinitely. What if the goods are, say, perishable, like fresh produce, or really expensive to store?
Good question. Article 1781 addresses that. If the goods might spoil, or storage costs are excessive compared to their value, the debtor can ask the court for permission to sell them,
Sell them? How?
usually by public auction. Or if there's a standard market price, like for stocks, or if an auction would be too costly, maybe a private sale. The money received from the sale is then deposited instead of the goods.
That makes practical sense. Avoids waste. So once a debtor deposits the goods or the money from the sale, are they automatically off the hook? Is the obligation fulfilled?
Not quite automatically. Article 1782 says the deposit needs to be validated by the court. The court confirms that the deposit was done correctly and was justified by the circumstances.
So another judicial check.
Yes. It provides legal certainty that the debtor is properly released from their obligation.
But then Article 1783 adds a twist. It says the debtor can actually withdraw the deposit even after it's validated, as long as the creditor hasn't accepted it yet. But doing so brings the original claim back to life. Why allow that?
It reflects the idea that until the creditor formally accepts, they haven't taken ownership. The debtor technically still owns the deposited item or funds, so they retain the right to reclaim it. But the consequence is clear. Withdrawing, it cancels the effect of the deposit, and the creditor's original claim is revived as if the deposit never happened. It sort of puts pressure on the creditor to act.
Interesting dynamic. Okay, let's shift gears to the other main remedy besides enforcement, canceling the contract altogether. Article 1784 talks about judicial cancellation, going to court to end the agreement.
Yes, that's the standard path if one party hasn't performed by the agreed time. The other party can ask the court to formally dissolve the contract.
Does the court just automatically grant cancellation if performance is late?
No, not necessarily. The court has discretion. Article 1785 is key here. It says the court should consider good faith, and importantly, only cancel if the non-performance constitutes a fundamental breach.
Fundamental breach. That sounds significant. What does it mean?
It means the failure to perform has to be serious. It has to affect the very core, the essential basis of the contract. So significant that the innocent party likely wouldn't have made the deal if they knew this breach would happen.
So, not just any minor hiccup. It has to really undermine the whole point of the contract for the person asking for cancellation.
Precisely. A minor delay on a non-critical part probably isn't enough. Failure to deliver the main thing you contracted for, that's much more likely to be seen as fundamental.
Okay. But there are also ways to cancel without going to court. Unilateral cancellation. Articles 1786 to 1789 seem to cover this.
Yes, in specific circumstances. The first one, in 1786, is if the contract itself contains an express cancellation clause.
So if the parties wrote into the contract, if party A fails to do X by date Y, party B can cancel immediately.
Exactly. If the conditions outlined in that clause are met, the innocent party can generally rely on it to cancel unilaterally without needing a court order first.
Makes sense.
Yeah.
What's another scenario for unilateral cancellation?
Article 1787 refers back to situations involving compulsory time limits, those deadlines we discussed earlier that are absolutely critical, like the wedding catering example.
Right. Articles 1770, 1774, 1775b.
Yes. If performance must happen by a certain time and it doesn't, the creditor can often treat the contract as canceled once that deadline passes without performance.
Because the performance after that point is basically useless.
Exactly. Time was of the essence.
Okay, Article 1788 seems similar, talking about impossibility or delay, making the contract pointless. How is that different?
It's related but often involves external factors. Think of a situation where, say, a natural disaster makes performance permanently impossible, or new law suddenly prohibits the contracted activity. It's not just about the debtor failing, but circumstances making the contract's foundation disappear. The innocent party might then cancel unilaterally.
I see. And the last one, Article 1789, deals with anticipatory breach when one party clearly says they won't perform in the future.
Right. If someone unequivocally states they're going to breach the contract before performance is even due.
So you don't have to wait for the deadline to pass.
Not necessarily, but it's nuanced. Usually, you still need to send a default notice, giving them a chance to retract that refusal. And they can prevent cancellation by providing adequate security, like a guarantee, within 15 days. Unless their refusal was stated clearly in writing. In that case, the law considers it more definitive, and the innocent party can usually cancel immediately without the need for that default notice.
Okay, that covers enforcement and cancellation. Now, the third remedy, compensation for damages, getting paid for the harm caused by the breach. Article 1790 says you can seek this alongside or even instead of enforcement or cancellation.
Absolutely. Compensation is a distinct right. Even if you manage to get the contract enforced or you choose to cancel it, you can still claim money for the losses you suffered because of the breach. Lost profits, extra costs incurred, that sort of thing.
And how is the amount of compensation decided? Paragraph 2 of 1790 says it's generally based on the rules for extra contractual liability, which is basically tort law, unless contract law specifies otherwise.
That's right. It borrows principles from tort law, aiming to put the injured party back in the financial position they would have been in if the contract had been performed properly. But the specific contract law articles that follow provide important rules and limits just for contract breaches.
Okay, so Article 1791 says compensation is generally due just because non-performance happened, even if it wasn't the debtor's fault in a moral sense. But there's a big exception, force majeure.
Yes, force majeure is the key defense against liability for damages when non-performance occurs.
We hear that term a lot. What exactly qualifies under this framework?
Article 1792, defines it pretty strictly. It has to be an event that the debtor could not have reasonably foreseen, and which makes performance absolutely impossible. Not just difficult, not just more expensive, but impossible.
Unforeseeable and insurmountable.
Correct. Article 1793 gives examples like major natural disasters, acts of war, unforeseen government orders making performance illegal, maybe even the death or sudden serious illness of the debtor if the obligation was highly personal.
And crucially, Article 1794 lists things that usually don't count as force majeure unless the contract says otherwise, like strikes.
Right. Strikes, changes in the price of raw materials, new laws that just make performance more expensive or difficult. Those are generally considered business risks that the parties are expected to manage or allocate in their contract. They don't typically excuse non-performance.
That's a really important clarification. Now, Article 1795 brings up a distinction, obligation of means versus obligation of result. How does that affect liability for damages?
This is a key concept. An obligation of result means you promise a specific outcome. If you don't achieve it, you're generally liable unless force majeure applies. Think of a contract to build a bridge to certain specifications.
Okay.
An obligation of means, however, means you only promise to use reasonable effort, skill, and diligence towards achieving a result, but you don't guarantee the result itself.
Like a doctor treating a patient.
Exactly. The doctor promises to use proper medical skill and care, but doesn't guarantee a cure. If the debtor only had an obligation of means, they're only liable for damages if the creditor can prove they were negligent or didn't act with the required skill or care. The burden of proof shifts.
Got it. Big difference in what needs to be proven. What about gratuitous contracts where one party gets a benefit for free? Article 1796 seems to lower the bar for liability.
It does. If you promise to do something for someone purely as a favor, with no benefit to yourself, you're generally only liable for compensation if your failure to perform involved grave fault. A higher degree of negligence or misconduct is required.
Seems fair, given the lack of exchange. Now, Articles 1797 and 1798 deal with communication and timing. One requires warning about potential problems.
Yes, 1797 says if you realize something might prevent you from performing, you have a duty to warn the other party promptly. If you fail to warn them, and they suffer damages they could have avoided with a warning, you might be liable for those specific damages.
Encourages transparency. And 1798 says if force majeure happens after, you're already late, already in default.
Then you can't use the force majeure event as an excuse. Your prior failure to perform on time means you bear the risk of subsequent events that prevent performance. You were already in breach.
Okay, timing is critical there. Finally, how are the actual damages calculated? Articles 1799 to 1801.
Article 1799 sets the baseline, the normal amount of damages. This is what a reasonable person at the time the contract was made would have foreseen as the likely loss resulting from this kind of breach.
Foreseeable damages.
Right. But Article 1800 adds that if the actual damage suffered turns out to be less than that foreseeable amount, you only have to pay the lesser actual amount.
Okay, capped by actual loss.
But then, Article 1801 increases potential liability in certain cases.
Yeah.
If the debtor was specifically warned beforehand about special circumstances, that would lead to unusually high damages.
Like, if you don't deliver this part on time, our entire factory will shut down.
Exactly. If they were warned, or if the non-performance was intentional or due to gross negligence, then they can be liable for the full, greater amount of actual damage suffered, even if it wasn't typically foreseeable.
So intent and warnings matter. And we should quickly mention Article 1803, which has specific rules for interest on late money payments.
Yes, that provides a standard way to calculate damages for simple delays in paying debts.
Okay, wrapping this up then. This deep dive really shows that understanding these legal consequences of non-performance is incredibly valuable for anyone dealing with contracts.
Absolutely. It gives you a framework for your rights and what might happen if things go wrong. It's a complex area, though.
Definitely. What we've covered gives a solid foundation, but specific situations can get tricky. Professional advice might be needed.
Always a good idea for complex cases.
Reflecting on all this, the default notices, enforcement challenges, cancellation rules, damage calculations, it really highlights the need for care when drafting contracts. So thinking about protecting oneself, what's a key takeaway for our listener when they're entering into a contract given these complexities?
That's a great concluding question. I think, based on everything we've discussed, the most crucial thing is clarity in the contract itself. Be explicit. Define the obligations clearly. Set unambiguous deadlines, especially if timing is critical.
Spell it out.
Yes. And consider addressing potential breaches directly in the contract. Maybe include conditions for cancellation, or even agree on liquidated damages for certain types of foreseeable breaches if appropriate. Being upfront about any special circumstances that could lead to significant loss if a breach occurs is also vital. Prevention through clarity is often the best protection.
Excellent advice. Clear contracts can hopefully help avoid many of these complex remedy scenarios altogether.
Well, this has been a fascinating deep dive.
Indeed, it has.
We hope this exploration of the legal landscape around contract non-performance has been insightful. We encourage you to maybe look further into the sources or related principles if this area interests you. Thank you for joining us.